Am I audible? Everyone? Am I audible? Am I audible? Everyone? Link spread. Am I audible? Visible, everyone? Yes. Hello. Everything is visible, audible, yes or no? Yes, I'll share the PDF notes, but at the end. At the end. Call your friends, everyone. Sound is audible okay or not? Everything is clear? Okay. I put video for LLP. LLP already video is there. Video is there on the channel. So we'll be revising unit number 4, 5 and 6 on your request, as everyone has requested me. Everyone has requested me for 4, 5 and 6 unit. So here we are with 4, 5 and 6 unit with all the summary notes. We'll try to revise within 2 hours, max to max. Law marathon in English. You make sure that at least, as when we decided to have this lecture, almost 80 students said yes, that they will attend, but right now the number is so less. For English, you may ask to your management. They have already my video, special video of amendments which we discussed during our lecture also. So you may get that lecture only, and you can watch that because we had specific lecture for RLP amendments. So you can go and watch that lecture if you want completely in English then. Yes. Okay. So just ask all of you, all your friends to join, and then we'll start within a minute. We'll be starting with unit number 4, then 5, then 6. I'll be giving these notes, but at the end of the lecture, or after uploading lecture, uh, what I can do is I'll just post all these notes in the description box of this lecture, either by tonight or by tomorrow morning max. Okay, so that you will get this also and you can watch the lecture also. Okay, ma'am, share notes for Indian contract whole notes, ma'am. As of now, I have only 4, 5, 6 for all of you. Because that too, on the request of the students, I have decided that let's conduct this session. Let's prepare notes for them, handwritten notes for them. So because of your request only, I have prepared. But yes, again, I'm expecting at least the number should be more than what is appearing right now, correct? So I'll be sharing 4, 5, 6 for sure with all of you. All right. So shall we start? Everyone? With lots of energy, everyone. Yes or no? At the end, I'll discuss how to write answers of this question, of these kinds of question, case law based questions also. So please just, okay. All right. So let's start, everyone. So first of all, understand, we'll be starting with the performance of contract. Let me just post this on Insta also, live started, so that if anyone is still not joined, they'll get the notification and they'll join the session. Okay. If you guys remember what we discussed, all right, let's start. So if you guys remember, we discussed, I've already taken your unit Companies Act, Indian Limited Liability Partnership Act and Partnership Act. Now we'll be discussing Indian Contract Act. In that also unit number 4, 5 and 6. All right. So with lots of energy, let's start, everyone. We'll start with the section number 37. Okay. So first of all, unit number 4 talks about the performance of a contract. Unit number 5 talks about the bridge of the performance, and unit number 6 is all about the contingent contract and quasi contract. Only 2 contracts are there in unit number 6. So let's start with unit number 4, performance of a contract, section 37, that is obligation of the parties to contract. Understand, whenever you are entering into a contract, obviously both the parties have some obligation and both the parties have some rights also. If I enter into a contract with all of you that will you buy my car for rupees 10 lakh, so that means I have an obligation to give you that car and you have an obligation to give me 10 lakh rupees, correct? Yes or no, guys? Yes or no? Correct. This is nothing but what you are entering into a contract. So after entering into a contract, you are having a obligation to perform that contract. Now what happens, understand, while performing, either you will perform that contract or either you will offer to perform that contract. That means what? Either you perform means you are actually performing a contract. That means I am taking that car to you and I am giving you that car. That means I am doing that actual performance. But offer to performance is what? Offer to performance is nothing but the offer or the attempted performance. That means what? Attempted performance means what? You are not entering into an actual performance, but you are just attempting to perform. Okay, so offer to perform, attempted to perform, tender to performance, these all means offer to perform. So first of all, whenever you are actually performing, then means what? When a party to a contract has done what he had to be undertaken to do, or either the parties have fulfilled their obligation under the contract within the time and manner as may be prescribed according to your act, according to your time and manner, you have performed the contract, you have perform the contract. That means what? That is actual performance. I have already given you the example. Another example is we have decided that you will pay me the fees and I'll conduct the lecture. So in this I am teaching you, that is nothing but I am doing actual performance. The second is offer to perform. Offer to perform means what? Attempted performance. Here what happens, understand, this is important. When the when the performance becomes due, the promisor offered to perform his obligation, but the promisee refuses. Understand what happens. For example, if you have ordered a cake, okay, whenever you are going to some bakery shop and you order a cake, it will take a day maybe to make that entire cake, and then he will deliver to you. Now what happens is, bakery person is done with the all the cake preparation. Your cake is ready and he is calling you continuously, but you are not receiving the call. That means the promiser has a obligation that he should deliver the cake to your doorstep. But now, because you are not answering the call, you are not ready to accept the delivery of that cake. That means here the promisor attempted to perform, but because the promisee refuses, I am not able to perform the contract. That is nothing but what? Offer to perform. This is nothing but what? Offer to perform. Now what happens if, in case, what happens is any of the promisor is died, then what happens? Their legal representative are required. Their legal representative may perform the contract, provided the this contract is not involving any personal skills, personal nature, personal confidence. That means, for example, teaching is a personal skill. Instead of me, any other person as a legal representative representing on behalf of me will not be allowed. Why? Because that teaching skill, or maybe painting, singing, these involve the personal skills, and if personal skills are not involved, then that contract will not be considered as a that contract will become void, because it is including personal skills. I hope you understand. Whenever if the contract is of personal nature, personal skills are involved, then the contract cannot be performed by the person. Then the contract cannot be performed by the person or legal representative, and contract becomes void. This question is quite important because of subsequent impossibility. For example, if you are entering into a contract with some publisher for writing a book, as an author, you have the knowledge, you have that personal skill of writing a book. Now, because now when you decided to enter into a contract, it was a valid contract, but afterwards assume that the writer is no more, writer is dead. Now what happens? Because writer is dead, instead of him nobody else can write that book, so that contract becomes void itself. Okay, I hope you understand. Now understand, attempted to performance is nothing but you are entering into a contract today, but you're going to perform it in the future. And you attempted means what? You try to perform it, but because of some reason you are not able to perform it, because maybe the your promisee refuses, or maybe some other situation happens. Because of that you are not able to perform. Now is it okay? Yes. All right. Now, this is all about section number 37. So, we'll just sum up this section number 37. This is quite important from your examination perspective also. What happens in section 37? Section 37 talks about the obligation to perform a contract. In obligation to perform a contract, we have either actual performance or attempted performance or tender of performance, whatever you want to say. Actual performance, where whatever the work you have decided, the promisor has done that work according to the time manner prescribed in the contract. Attempted performance means promisor want to perform the contract, but the promisee refuses, because of which you are not, as a promisor, you are not able to perform it. The second thing, if in any of the situation promisor died, then their legal representative are responsible to perform a contract. Now understand, legal representative means any of the person who is authorized to perform a contract on behalf of promisor. For example, your parents, baby, spouse, children, anyone who is related to you are legal representative. So they will be performing that contract. But if the contract is something where personal skills are involved, it is of personal nature, personal confidence, then legal representative cannot perform, and that original contract becomes void. I hope entire thing is sum up in just 1 minute. So this is quite important. Now we are going ahead with the section number 38. 38 talks about effect of refusal to accept the offer of performance. What happens? Understand, whenever someone is refusing, we just saw that promisee may refuse. Now if the promisee refuses, then what happens? That means you are offering to perform, promisor has offered to perform, but the promisee refuses to accept the performance. Now because promisor is not responsible for non-performance, and he has not lose any of the rights under this contract. What happens? Understand, if for example promisor, as I have already gave you the example of cake bakery, or maybe I'll give you the second example, like whenever we are discussing about the let's take an example. I have decided to conduct a lecture for all of you, and I am trying to perform. So from my side, I am supposed to teach you, and from your side, you're supposed to pay me the fees for this. Now you have already paid the fees, but what happens? I came in the classroom, but what happens? You all decided to do mass bunking. Okay, you all decided to do mass bunking. I am there to perform my obligation, but because promisee refuses, I am not able to perform my contract. That is nothing but what? Attempted performance. That is nothing but what? Attempted performance. I am not responsible for the non-performance, because I tried to perform my obligation, but because promisee refuses, it's not my duty. So because of that, I have my rights intact, that I tried to perform, but you refuses. The conditions for this is, it must be unconditional. First of all, understand, it must be unconditional. The second, it must be made at a proper time and place and with the reasonable opportunity. The third is deliver anything to the promisee must have the reasonable opportunity of seeing. That means what? Seeing of the things offered means what? Whenever you get, for example, whenever you get any of the parcel or courier from Flipkart, Myntra, Amazon, whatever, you have the opportunity to check that. And unless otherwise you check that, you should not get take that parcel. But now what happens is, if the promisee offer is an offer to deliver anything to the promisee, must have the reasonable opportunity also. But if you did not get the opportunity, that means what? Again, you have refused to perform that particular promise. So here, understand, here what happens? Promisor is performing, but the promisee is refusing. Promisor is performing, but promisee is refusing. Section 38 and 39 is more of a related to the next unit, but here I just included this so that you get the sequence. That's the only reason. So understand section number 38, and now section number 39 talks about effect of refusal of the party to perform the promise. Now understand, in section 38, promisor was performing, but the promisee failed to perform. Promisee refuses to perform. In section 38, promisor himself is not performing. So in earlier, promisor was performing. Here, promisor is not performing the contract. So now what happens? What will be the effect? When a party, that is party to the contract we are talking about, that means promisor has refuses to perform. Promisor himself refuses to perform. I have decided to conduct a lecture, but I did not appear. That means I have refused to perform or disabled himself from performing himself from the promise in its entirety. That means what? Disabled himself means what? For example, A decided to marry B, but instead of marrying to B, before marrying to, let me just draw, A decided to marry with B, but before this marriage, A marries with C. Now obviously A has disabled himself from performing the contract between A and B. This is nothing but what? Promisor disabled himself from performing his promise in its entirety. The promisee may put to an end the contract unless he means what? Promisor signifies his word or the conduct or acquiescence of continuance. That is nothing but unless otherwise promisor shows by his actions or by expressly by spoken words or oral words, whatever written words, either otherwise agreed, the promisor, by promisor we will consider it as a continuance. But if he only, that means promisor only signifies his either by through the action or through by the words, by through any of the means, but promisor should show that he want to perform the contract and it is possible to perform a contract. Otherwise we will consider as a contract to put to an end. The rights of the promisee in this situation where the promisor is not performing the contract, then the rights of the promisee are first terminate the contract. That means if I decide to, we decided that I'll teach you, you will pay me the fees, I did not appear in the classroom, then you have a right first to terminate the contract. The second, to indicate by the words or by the conduct that he is interested in its continuance, or I'll just message you, see, due to some emergency I did not appear, but we'll conduct our lecture tomorrow. Either in this way I am indicating you, either by words or by orally spoken, written, whatever, by way of any of the ways, I am delivering my message that I am interested in continuance of this contract. Or third, claim the damages that he has suffered. That means if you suffered any damages because of me, you can claim for those damages on this breach. So as a promisee you have three rights. The first is to terminate the contract. The second is you unless otherwise, either you should get the indication from the promisor for the continuance, or the third, you can claim for the damages. This is nothing but section number 39. The next is section 37, 38, 39. Section 37 talks about the obligation. Obligation, two types. One is actual performance by two ways. One is actual performance, that means has done the work, and the second is attempted for the performance. In this, promisor perform but promisee refuses. The effects of this is given under section 38. Whenever the person is coming and actually performing, then what will happen? And the section 39 talks about where promisor himself is not performing, then promisee will have certain rights. In that we had the 3 points, and we are done with the section number 39 also. So now we will have the very small concept of succession and assignment. Now understand succession and assignment. Succession, you may get a 2 mark of question on this. Succession is nothing but you get the burden, or you all get the burden also and benefits also. Means what? If you are getting any ancestors property or any grandfather's property, parents property in your own name, you will get their obligations also. In succession, you will get the right also and you will get the obligations also, liabilities also. But in case of assignment, you get only benefit and you don't get any of the liability or the burden of any other person. So this is the basic difference between succession and assignment. Now very important part, we will be starting with the section number 40, 41, 42, that who should perform the contract. Okay, who should perform the contract? I have divided into 3-4 parts. The first is the promisor himself. See, there are certain kinds of contract which may involve the personal skills, personal nature, personal confidence, in which that person, the promisor, only supposed to perform that contract. Otherwise it will become void. Let's take an example for what happens. First we'll read and then I'll give you the example. If the intention of the party is that the promise should be performed by the promisor himself, and the contracts involving personal skills diligence which are founded on the personal confidence between the parties to be performed by the promisor himself, only promisor. For example, I'll give you a classic example, understand. Okay, slow, all right, no problem. I'll go slow, no problem. Okay, so understand, I'll give you an example for a promisor himself. Okay, understand, let's take an example that you have appointed some lawyer or ABC. This person is A. This person has appointed B as his lawyer. Okay, this person is a lawyer. Now what happens, understand, this person murdered somebody. Assume this person is dead, right? C is dead. What happens in our partnership also? C is always dead, correct? So C is dead, C is murdered by A, correct? Now B is a lawyer. A asked B that you supposed to fight my case in a court of law. Now B is saying, no, I am not in your city right now, I am out of station right now, so you can ask my colleagues to perform this contract, or you can ask my friend to fight a case on my behalf, or instead of me he will fight your case. But now understand, the person who is fighting a case will have his personal skills involved, his judgment, experience, expertise, diligence. He know the scenarios, correct? So this person only supposed to fulfill that contract, because he cannot ask C to perform on B's behalf. Why? Because this is specifically because of personal nature contract. Or for example, if you have paid the ticket, if you paid for IPL ticket, correct? Now if Dhoni is not performing, specifically you're going for a Dhoni, now Dhoni is not performing, that means Dhoni is not coming for a batting. Now what will happen? One of the in one of the interview, one of the cricketer also mentioned this, that there should be a clause that while buying any of the ticket, there will be a clause that if Dhoni is not performing at least one over, then entire fees will be refunded to all the viewers. So this was the clause which they want to funny was it was just a funny clause. It is not a reality, but yes, it's assume that this is a clause. Now you are going and just to see Dhoni, and Dhoni did not appear. Obviously you should get that money back. Why? Because promise, or instead of Dhoni you are getting any other person, as you can see that okay, as it is Chennai is winning, so it doesn't matter whether Dhoni is there or not. This is not the case, correct? Yes or no? Let me just know. Yes or no? You are going to watch Dhoni, or maybe you have you got a ticket for any concert of Arjit Singh, or maybe some Michael Jackson kind of a person who is having some personal skills. And if you just go there and you did not see Michael Jackson, instead of that someone else is performing, as it is that that concert, or the organizer can't say that as it is the concert is done, now you won't be getting any refund, or you won't be getting any fees. Obviously promisor is somebody who's supposed to perform that promise. Why? Because it's a personal skill promise. Or you may go to some painter and that painter says that my colleague will paint your picture or something. No, that is not allowed, because promise should be performed by the promisor only. CSK, correct? Yes. Okay, so first of all, understand section number 40, where promisor himself perform the contract. Now second situation, where agent is performing on behalf of promisor. I hope you understand agent. Agent means any person. Agent means any person who represent himself. Here legal representative is different and agent is different. Legal representative means some relative kind of person, like either spouse, friend, either spouse, mother, father, parents, children, anyone who is authorized. And agent is somebody who is authorized on his behalf, maybe having blood relation or not having, or any kind of relation with him, maybe the outsider, or maybe some organization person can appoint any I can appoint any marketing agency as my agent also. So agent will be any person to whom I have given the authority to perform for me. That means agent, correct? So now in this situation, some situations agent can also perform the contract. So first of all, promisor will perform the contract according to section 40. Then second, agent will perform according to section 50, according to section 40. So promisor, and then second will be agent. The third will be legal representative. When will legal representative perform the contract? Just let me know quickly. Or in case of death of the promisor. In case of death of the promisor, what will happen? The legal representative should perform the contract. But now understand, this is the very important clause. The liability under the contract is limited to the value of the property they inherit because of the from the deceased person. Now understand this one line very sincerely. Can a legal representative appointed as an agent? Yes. He can. Legal representative, understand with the example. Now what happens is, understand, A is dead, no more. Okay. Now on his behalf, there is Mr. B, who is legal representative of A. Okay. He is legal representative of A. Now what happens is, A's assets are worth 50k and his liabilities worth 60k. Correct? His assets were worth 50k and liabilities worth 60k. These assets obviously along with the liabilities also. So now 50k against 50k, legal representative obviously will get the asset of 50k and will pay liabilities of 50k. But what will happen about the 10k of liability? What will happen about the 10k of liability? 10k of liability, a legal representative should not pay from his personal assets. Are you getting my point? That means what happens, understand, legal representative will not pay from his personal assets. Means if he is getting assets of the deceased person, he is getting liabilities of the deceased person, then he should apply these assets against the liabilities. If something is still pending, some liabilities are still not paid, legal representatives' personal assets are not liable to pay off the liability of the deceased person. Are you getting my point? So that's why understand very clearly that in this situation, even though we are taking legal representative, making him liable, giving him assets, but his personal property cannot be used for the, his personal property cannot be used at all for the paying off the liability of the deceased person. I hope you understand. I hope yes or no. Just let me know yes or no. Then the next is third person. Understand what about the third person? Third person means a person who is not even the agent, or the third person who is not even the legal representative of the promisor, but still he performed the promise. But still what happens? He performed the promise. And now what he the question is, yes, so what he inherited from him parents to the extent he is liable. Correct? Yes, correct. All right, now understand the third party. Once accepted the promise from a third party, you cannot enforce the promisor afterwards. I'll give you the example, classic example for this. Understand very clearly. Classic example for section number 47. So first of all, understand, we just saw section number 40, in which we discussed that promisor supposed to perform the contract. In section 40, we discussed agent can also perform the contract. In section number 41, we saw that legal representative is performing the contract. Now section 42, we are discussing any third party is performing a contract. Now the third party cannot be, may or may not be the legal representative or the agent. Third party is somebody else only. Now how this will work, understand. Here one person is there, Mr. A. We'll take a example from you also, but later on. And here we have Mr. B. Mr. B lent rupees 1 lakh, to Mr. A. Okay, B lent rupees 1 lakh to Mr. A. Now what happens, understand, Mr. B unable to pay off the debt. he lost this money, unable to pay off the debt. He lost this money, and now maybe in the casino or somewhere else, he lost this 1 lakh rupees. Now Mr. B is asking that, and this was decided after a month. A will repay this money to B. Now what happens is, after a month also, A is not paying to B. This is the scenario. Okay. Now here everything is, she is the special friend, I would say. Special friend. She is a special friend of Mr. A. She is a special friend of Mr. A. She is just, what you can say, just overseeing the entire matter. And now she can see that Mr. A is in stress and he is unable to pay rupees 1 lakh. As being a third party, she is not even an agent right now, because A has not authorized special friend, his special friend. She is not even a legal representative. Why? Because they are not married yet. She is just a special friend. So she is not a legal representative. She is not even agent, as A did not authorize her. So now what happens, even after that, this special friend pays 1 lakh rupees to Mr. B. This special friend pays 1 lakh rupees to Mr. B on behalf of A. Now what happens, this 1 lakh will be as good as giving 1 lakh by A only, and B cannot enforce A afterwards. Afterwards means after accepting 1 lakh from his special friend, B cannot ask A to repay money again. Are you getting my point? So third party can also pay on behalf of your promisor, but afterwards you cannot enforce the promisor for that. Are you getting my point? Yes, section 41 talks about this. So section 40 talks about three people: promisor, agent and legal representative. Yes, correct. We are not discussing their personal matters, but yes, all right. So understand, third person can also pay. Now we'll just what you can say, we'll just revise everything once again, then we'll go ahead. Section 37 talks about the obligation. I'll be very fast in next 1 minute, so please make sure that you are very attentive towards my lecture. So section 37 talks about the obligation of the parties. That means you're supposed to, either you will perform the contract actual performance, or you will be having the attempted to perform. Actual performance means where you are actually going to done that work, and attempted to perform where you are as a promisor you are performing, but the promisee refuses to perform. Promisee refuses to accept your performance. In case of death of the promisor, legal representative is supposed to perform that contract. But if the contract is of the nature of personal skills, judgment, or personal confidence, personal nature, diligence, then that contract will become void automatically. Legal representative shall not be perform that contract. Then section 38, where the promisor is performing but promisee is refusing. So there are certain situations where promisor is performing and promisee is refusing. Section 38, you won't be getting much of the questions. You will get question on attempted performance for sure. Understand, if they want to ask a few questions from unit number 4, first question which you may get in your exam will be on attempted performance. The second will be either on section number 39 or the 40, 41, 42. So 39 talks about where the promisee is promisor himself is not performing a contract. So if promisor not performing, then promisee will have the right to terminate the contract, where to get the damages, or where to get the indication from the promisor, that either express or by implied ways. Then understand, we just saw that section number 40 talks about where the promisor is performing himself should perform the contract whenever it's personal nature. Section 40 talks about the agent can also perform the contract. Section 40 talks about that when promisor is no more, promisor died, then on his behalf legal representative can perform the contract. Then section 41 talks about the third person can also perform on the behalf of promisor, but afterwards, once the third person performing that contract, the promisee cannot enforce promisor afterwards. I hope you understand section number 37 to 41. Any doubt, just let me know. All right. Now we'll go ahead with the, no doubt. All right. Now we'll go ahead with the joint promissor, that is section number 42. What happens? Understand section number 42. Unless contrary intention appears, this is very important line. Unless, this is very important section also, section 42, you may get one question on joint promissor. So unless contrary intention appears, joint promissor is liable. But unless contrary intention appears means what? Joint promissor means everyone is liable for everyone's liability. It's kind of a partnership. You understand partnership, partners' liabilities jointly and several partners are jointly and severally liable. That concept is here also. Understand that joint promissor means what? That all the promissors are liable in case of each other's liability. That means assume that, let's take an example that here Mr. A, Mr. B, Mr. C. Okay, A, B, C. They are the joint promissor. Now everyone has taken a loan of rupees 50k. Assume everyone has taken a loan of rupees 50k. Now this 50k, what happens is they are joint promissor. Now as a promisee can ask or promisee can compel any one of them unless otherwise agreed. Means what? Promisee, here Mr. D is there, he is a promisee. Okay, Mr. D is a promisee. Mr. D can compel this 1.5 lakh all put together from Mr. A only. He can, unless otherwise agreed, he can. But now if this happens, what will happen? What will be the consequences that we'll see in the next section. But right now understand, he may ask any one of them, he may compel any one of them unless otherwise agreed. But if this is agreed that everyone will bear their own liabilities, everyone will, A, B, C will bear their own liabilities, then what will happen is, if A should supposed to pay his share, that is 50,000, B supposed to pay his share of rupees 50 and C supposed to pay his share of 50k. Let's assume C died. And in the contract it was decided everyone will bear their own share. What will happen? His legal representative will be liable. So if all the promissors are alive, everyone will pay their own shares. If one of the promissor died, then legal representative of that deceased promissor along with the surviving promissor will pay. And if all the promissor died, assume all the promissor died, then everyone's legal representative will be liable. Now don't ask a question then what will happen if everyone's legal representative are dead. Please, don't ask these questions. Don't try to kill everyone. So just only understand, unless otherwise agreed. If all the promissor, all of them are liable. If any one of them died, all the surviving promissor along with the legal representative, if all the promissor dies, then everyone's legal representative will be liable. This, you may get one question on this, and you may get one more question which we'll be discussing in section number 43. This is all about the section number 42. Legal representative will be liable in case of deceased promissor. Now, section number 42, we have already gone through. Now, section number 43. This is important. Any one of the promissor may compel in the absence of the express contract. These are the lines. Understand what happens is, student don't understand what to write in the exam and what to skip from the exam. Okay. So, please understand that whatever is given in these notes, you supposed to write that. Okay, you're supposed to write that much at least. If you write only these 4 lines also, they are more than sufficient whenever you get a question on section number 43. So these 4 lines are, in the absence of the express contract, the promisee may compel any one of the such joint promissors to perform the whole of the promise. As already discussed, D can ask from A only to pay him 1.5 lakh. So 1.5 lakh is their whole of the promise. Whole of the promise was not 50,000. Whole of the promise was 1.5 lakh from A, B, C, 50, 50, 50. So all put together is 1.5 lakh. So D may compel any one of them. That is A. In our example, he may compel any one of them. Now, if what happens? If any one of the joint promissor is compelled, the other promissor should contribute equally. That means what? Other promissor should contribute equally. Now, understand very clearly. Here we have Mr. D. Here we have A, B and C. Okay, A, B, C. What happens is, for example, if D compelled A only, if D compelled A only to pay his 50,000, then 1.5 lakh, then what happens? This promisor will get a right to recover this from the remaining promisor equally, contributing equal. That means he will ask, his share was only 50,000, so remaining is 1 lakh rupees. 1 lakh rupees he may ask it from B also, he may ask this from C also. Okay, first of all that. The second situation, what happens? Second scenario, understand very clearly, you may get a question on this also. So A, B, C are there, A, B and C. Everyone is having the liability of 50k, 50k, 50k. What happens? A becomes insolvent. A has the assets. A has the assets also, but it's only of 20 worth 25k, and he becomes insolvent. He becomes insolvent. What happens if he becomes insolvent, and if they are the joint promisor, and unless otherwise agreed means what? If they have not agreed that everyone will bear their own liabilities, they haven't agreed, that means everyone is liable for each other. That means, if unless otherwise agreed, if this is 50,000, this is 25,000 of worth asset, 25,000. Now what will happen with the remaining 25,000? A will pay his own share of 50k, B will be paying his own share of 50k, along with this 25k, distributing equally among each other. Along with this 25k distributing among each other. So they will be liable for 62.5k. 62.5k. I hope you understand. You should write this somewhere or take a screenshot of this. Otherwise, you may get this question in your exam. So understand, depending on the situation, demanding, if anyone, if promisee demanded from any one of the promisor, any one of them, then the other will contribute to that promisee who was compelled. And if they are not compelled, and if one of the person has done some default, then the other will bear their share. Are you getting this point? Yes or no? Let me just know. Joint promisor and joint promisee. Right. Yes or no? Just write quickly. Yes. All right. Okay. So this is all about what? Section number 42 and 43. So understand 43, 42. If any one of them if any one of the joint promisor compelled, yes, okay, then contribute equally. In case of any of the joint promisor makes the default, if any of the joint promisor makes the default, then the remaining will bear the loss equally, but unless otherwise contrary appear, or whatever this line, this word is very, very important. Unless otherwise agreed, unless contrary intention appeared, you should write this these four lines, whenever these four words, whenever you are writing about section number 43. Nothing in this section shall prevent the surety from recovering from his principal the payment made to the surety on behalf of the principal, or entitle the principal to recover anything from surety. Did you get this line? Yes or no? Did you get this line? Just read it, explanations 43, and just let me know whether you understood this or not. Explanation to section 43. Did you get the question? This is all about the contract of guarantee. If you guys are aware, understood? Kya baat hai? Wonderful. Yes, wonderful. This is all about the guarantee contract, wherever the one person as a surety giving the guarantee on the behalf of the other person. That means he is, as a surety, he is liable for the, on behalf of the, he is liable on behalf of the promisor. That means he is liable on behalf of the principal debtor. Perfect. Now let's go ahead with the section 44 then. Release of one of the joint promisor. If in any of the case, in case the promisee release one of the promissor, then the other joint promissors are not discharged. That means what? There are three promissor, 1, 2 and 3. Okay, and fourth as a promisee, or A, B, C are the promissor, D is the promisee. Now D discharged A from his liability. D discharged A from his liability. This doesn't lead to a conclusion that B and C are also discharged. Are you getting this line? Yes, correct. Are you getting this line? If A, B, C are the promissors and D is promisee, D may discharge A from his liability because they are the joint promissor. This does not lead to a conclusion that B and C are also discharged from their liabilities. They're supposed to pay their own liabilities. Yes or no? Just let me know. This is all about section number 44. Section 45 is already included in section 42. So we are not going to discuss section 45. We will be discussing very important section only. You may get this in your, yes, okay, you will be getting this these notes in which you will be getting this time and place for performance. This is the section number 46, 47, 48, 49, 50. They are not crucial sections, so I am not going to take this, but this is the summary of section 46 to 50. If you get the any of the what you can say, any of the problem in this, you may ask on my Instagram or on Telegram. But yes, here only they are talking about somewhere a few situations where time is not mentioned, application is not also done, then reasonable time, the performance of the contract should be within a reasonable time. Reasonable time is a matter of fact, it is not defined anywhere. Sometimes time is decided, then you supposed to pay on that time only. If time is decided, place is decided, then you should perform at that time. If the proper place is not decided, then you should ask as a sometimes promisee should ask, sometimes promissor should ask for the place. So this is all about the section 46 to 50, not kind of important kind of a sections. You may also just read it once and you may also skip because it's high time for your examination will be very soon. You are going to appear in the examination, so you may skip it for as of for right now. The next is section number 51, which talks about the promissor not bound to perform unless the reciprocal promise ready or willing to pay. That means reciprocal promise is nothing but simultaneous performance. Like that means you should take it from one hand and you should give from the another hand. Okay, that means if you are if you are ordering something from Amazon, you just make a note that it will be cash on delivery. So in that situation, whenever you are getting that courier from that Amazon, then only you will pay. So you are getting it, you are taking the delivery and you are giving the cash. This is nothing but reciprocal promise. In a few of the reciprocal promises, this may happen whenever for the first, what you can say, first performance is already decided. So if the performance is ready, if the promissor is performing, then only you will perform. So if you are not getting the delivery of that goods, you are not supposed to pay for it. Otherwise, it is not something you pay, then you will get the delivery. If in case of, we are discussing in case of cash on delivery, correct? So if you are getting the courier, then only you will pay. This is nothing but reciprocal promise, in which you have decided the order either by contract or because of the nature of the contract. Cash on delivery itself is saying that first you will get the delivery, then you will pay the cash. So it is already decided. So it depends on the nature of transaction also sometimes. So this is all about section number 51, 52. Now we'll discuss about the section number 53, where we are saying that liability of the party preventing event which the contractors take the effect. That means what? The person, one of the party to the contract is preventing the another to perform his promise. Now what will happen? One of the party prevent the other. So first of all, one party, see, I am coming to for taking a lecture, but because you have decided for a mass bunk, I am not able to perform my promise, correct? So in this situation, one of the party was prevented because I can't teach to the walls or doors or to the blackboard or something like this. I am here just to teach you all. But if you did not appear, then there is no mistake from my side. So now what happens is this contract will become voidable at the option of the party so prevented. That means it will be voidable on the behalf of it will be void. It becomes voidable at my option, but not at the option of you, because I was prevented from performing my contract by you. So that's why first. So whenever you are preventing someone, that prevented party may make it as a voidable contract. The second is the preventing party is liable for the compensation, and the preventing party may resign the contract. I may say I will not teach you all. So this may also happen. So this is all about one of the party. If one of the party is preventing from entering into or from performing a contract. Now let's go ahead with the section number 54. These sections, like from 56 section to 54, they are not very strong or important section. They are kind of a 3-star kind of a sections. Whatever the what you can say, whatever, whenever I feel that they are very, very important, I'll specifically mention, and I will specifically discuss it in more and more detail. I will revise twice, thrice in this lecture only. So please understand. You may just go through this, but yes, these are just what you can say 3-star kind of a question which you may get in the exam. Section number 54, effect of the default as to that promise which should be performed first. That means if first person is not performing, the another person has no obligation to perform his contract. If you are not getting the delivery of the goods, you are not supposed to pay the cash. This is nothing but section number